Faili za kesi iliyowasilishwa mahakamani kupotea. Inadaiwa kuwa baba mzazi na mwanawe wa kike walikula njama kuwaua wanawe 4 wa kiume ili kujigawia mali yao, walakini waliotarajiwa kufanya mauaji wakatibua njama hiyo baada ya kupokezwa shilingi milioni 3.2. Mwandishi wetu Willy Dennis Njiro yuko pamoja na wao kwenye afisi za ODPP mjini Naivasha na tunaungana naye kwa mengi zaidi. Njiro.
Naam, asanti sana mwenzangu Andrin Kilemi, mbashara kutoka afisi za ODPP hapa mjini Naivasha, ambavyo kama unavyoona nyuma yangu ni kwamba familia hii ambayo tayari ushadokeza kwa mtazamaji wetu inatafuta haki baada ya madai ya familia kwamba huenda mambo yasiwe kadri walivyotazamia ikawe wakati walifikisha malalamishi katika kituo cha polisi, na vile vile masuala haya yakaweza kufikishwa kotini. Yote tisa ni kwamba kumekuwa na hali ya vuta ni kuvute, afisi hii ikisema ingali inazidi kuchanganua swala hili, na familia kwa upande wao wanasema wanaona kana kwamba mambo haya kidogo yameweza kuchukua muda zaidi kadri ambavyo walivyokuwa wakitazamia. Ni wazi kwamba kumekuwa na dhibati kadhaa ambazo tayari zimewasilishwa kwao, lakini masuala haya tunawachia wale wako katika ulingo huo. Na pasi na kupoteza muda, karibia hapa utueleze jina lako ni nani, kwa sababu gani mko kotini kwa kwanza, alafu utueleze, usiguse masuala ambayo yapo kotini, alafu kisha utueleze sababu ile mko hapa ni gani.
Kwa majina naitwa Martin Jenga na mimi ni mkaaji wa Naivasha, ambapo tuko kotini kwa sababu ya kesi ambayo tuliweka kotini mwaka uliopita mwezi wa June tukiwa kama walalamishi, ambapo kesi ni kwamba ni conspiracy to murder, ambapo washtakiwa ni 4 akiwa wako mmoja wao amewekwa kotini, na kuna wengine wako nchini Amerika ambao ndio walikuwa main suspects, ndio walikuwa wanafadhili hiyo conspiracy ya kutumaliza, ambapo pesa kiasi cha milioni 3.2 waliweza kulipa kwa goons ndiposa waweze kumaliza sisi tukiwa 5 kama familia. Na kuja kotini kuweka hayo mashtaka imechukua muda, na tumeona mambo ambayo yamekuwa yakiendelea hivi kwamba kumekuwa na delays za hii kesi kutoka wakati ule, na tumeona ya kwamba kuna haki ambayo inajaribiwa kugandamizwa kwetu, na ndio tukaweza kusema siku ya leo tutakuja kuangalia tujue mambo yanaenda aje hapa hii ofisi ya ODPP. Na tulikuwa na majadiliano na bwana ODPP wiki iliyopita, na akatupatia siku ya leo tuje hapa ndiposa aweze kutuambia file ambayo aliituma Nairobi iwe reviewed iko wapi. Sasa tumekuja kwa hii ofisi na tumeweza kujua kwamba hayuko na ameona asiwe kwa sababu ya saa zake, lakini tunajua ukweli ulipo ni kwamba hayo malalamishi yetu ni valid. No wonder hapatikani kwa ofisi yake, na tulikuwa na appointment kwa sababu anajua kile ambacho kinaendelea, na sisi hatutakaa hivyo, tutafuata haki yetu, na ni lazima atoe hiyo file. Iko kwa dawati yake ameficha, na anataka tusiweze kupata haki yetu.
Hauna hakikisho la hilo kwa sababu hali ya ofisi nyingine hauifahamu, lakini kwa kifupi malalamishi haya yanahitaji uchunguzi zaidi, kwa sababu zile dhibati ambazo mmekabidhi kwao mpaka ziweze kupitiwa na kuhakikisha kwamba wahusika wenyewe wameweza kufikishwa pale kwa mujibu wa sheria.
Ni kwa hizo dhibati ambazo malalamishi yetu kwa hii ofisi, na tumeandika malalamishi kwa Ombudsman, tumeandika malalamishi kwa Nairobi Legal House, na sio ni jambo lingine, jambo linazunguka jambo moja, file. Kwa sababu tulikuwa hapa February na ikawa file imeenda review, jaji akawapatia 45 days. 45 days zikaisha, wakaomba 90 days. 90 days zimeisha. So we are going for a hearing ndiposa waende waombe another time period. Na unasikia vile mmoja wa afisa hapa anasema they are still as early as yesterday they were looking at the file. Which file now? Ambayo iko Nairobi ama iko hapa? Kwa
hilo hebu tukaweze kusikia kidogo kutoka kwa wale ambao wanahusika na ofisi. Kidogo kiongozi, nieleze jina, songa kidogo hapa kwa sababu ya kamba. Utueleze jina lako na kuna malalamishi haya, sijui pengine unaweza sema nini kufuatia haya ili kuwapa angalau matumaini.
Mimi kwa majina naitwa Joseph Abwajo, mimi ni prosecutor hapa. Na ile kitu ambayo nataka kusema kwamba hii ni ofisi ya mkurugenzi wa mashtaka ya umma na ofisi si mtu. Kwa hivyo sababu kwamba kwa sababu hatujatoa sababu zozote kwamba Mr. Wanga hayuko kwa ofisi ama hajakuwa, na kwa sababu yake ya kutokuwa ni kwa sababu ya kikazi ambayo ako mahali pengine, na sio kwa sababu kwamba kwa haya masuala ambayo inafanyika siku ya leo. Tuko na kesi mingi sana ambazo tunafanya kwa kila siku. Tuko na Wakenya wengi ambao tunahudumia kila siku ambao wanakuja katika hii ofisi kutaka kupata haki na wanaweza kuhudumiwa, na wengi wao wameweza kutoka wakiridhika. Na ile kitu ambayo tunafanya ni kwamba kama kuna malalamishi ambayo yameweza kuletwa na mtu yoyote yule, yanazingatiwa kulingana na vile yamekuja na kulingana na uzito wake na kulingana na yale ambayo yanaguzia. Kwa hivyo ukiona mambo imekuja, kila file inakuja kulingana na vile iko na inaangaliwa kulingana na misingi ya kisheria ambayo imeweza kuwekwa na ile ambayo imeweza kutarajiwa kama ofisi. Tuko na taratibu zetu za kazi ambazo tunafuata. Na yale mambo yote ambayo yamezungumziwa, vile nimesema pale awali, ni kwamba hamna faili yoyote ambayo inapotea kwa ofisi ya mkurugenzi wa mashtaka ya umma, kwa sababu ofisi ya mkurugenzi wa mashtaka ya umma haianzishi uchunguzi na haifanyi uchunguzi. Kitu ya pili ni kwamba zile file ambazo tunaweka hapa ambazo zinaletwa hapa ni file ambazo ni nakala. Zile file ambazo ni original huwa zinabaki pale katika kituo cha polisi.
Nashukuru. Yes. Asante sana kwa muda wako. Kwa sababu ya muda tutafikisha hapo mwenzangu Andrin Kilemi, ili tukaweza kukurudishia upande wako. Maswala ni kama hayo tu. Kila upande unazo changamoto, hawa wanalalamika, wale wanasema bado wangali wanafanya kazi yao. Yote 9 tutakuwa tukiyapigia upatu maswala haya mwendo wa saa 1 kwenye taarifa zetu, na tukitumai kwamba familia hii itaweza kupata haki kama viongozi hawa ofisi hii ya ODPP wameweza kuzungumzia hapa mjini Naivasha. Na kurejeshea usukani kwako mwenzangu Andrin.
Asante sana Willy Dennis Njiru. Bila shaka tunatumai kwamba familia hiyo itakuwa inapokea haki. Ni taarifa ambayo tunaifuatilia. Mtazamaji utakuwa unaipokea kwa ukamilifu wake kwenye taarifa zetu za saa 1 na saa 3 mtawalia. Katika taarifa nyingine ni kuwa katika hafla ya amani iliyofanyika eneo la Ileret, Daktari Raymond Omolo ambaye ni katibu wa Wizara ya Usalama amewahimiza wanajamii kufunga ukurasa wa migogoro na kuishi kwa amani, akiwataka Wakenya kwa ujumla kutumia njia za kisheria kupinga sera za serikali badala ya vurugu. Pia alionya watu hatua zitachukuliwa kwa wale waliozua vurugu katika maandamano ya Gen Z.
Out for what is good in their country, but to cause mayhem, to cause loss of lives and livelihoods. And what we are telling them is that each and every criminal must have their day before the courts of law, because we are a country governed by the rule of law and order. And if there are issues that would want to agitate or that would want to canvass, let's use the same constitution to be able to pursue.
Na mzozo unatokota kati ya viongozi na wakazi wa kaunti ya Vihiga kuhusu hatua ya serikali ya kaunti hiyo kutenga kiasi cha shilingi milioni 3.8 kwa ajili ya utunzi wa wimbo wa kaunti, yani County Anthem, licha ya serikali ya kaunti kupitia Gavana Wilbur Otichilo kusisitiza kuwa hatua hiyo inatokana na hitaji la kisheria. Baadhi ya wenyeji wameikosoa serikali ya kaunti wakisema kuwa kwa sasa wimbo wa kaunti sio hitaji muhimu na kuwa fedha hizo zinapaswa kuwekezwa katika miradi mbadala yenye umuhimu kwa wakazi. Tayari shughuli ya kukusanya maoni kuhusu utunzi wa wimbo wa kaunti imefanyika katika maeneo tofauti ya Vihiga, huku wenyeji waliojitokeza hasa vijana wakipinga hatua hiyo na kuitaka au kuitaja kuwa isiyofaa kwa sasa.
So please, introduce yourself. Sheria iko na anthem ndio inapatia sisi as a county mwelekeo. Ni kitu gani ambao tunataka ikulete pamoja? Ukisikiza national anthem, kila mtoto wote kwa primary kutoka kwa ECD anajua maana ya national anthem. So sheria inasema county anthem pia tutengeneze, na tuko na sheria yetu hapa ya kusema hivyo. So anthem ambao tunataka itengenezwe, na nataka kuchukua nafasi hii kuambia watu wa Vihiga, toeni maoni yenu. Hii anthem unataka ni vitu gani ambao tutaweka ndani ilete watu wa Vihiga wote pamoja, unity.
Department has money for the county anthem, but department doesn't have money for stadiums. Department doesn't have money for the youths. It's high time the leadership of this county department of the youth to come up clear to tell us the priorities.
Ikiwa tumekuwa kuanzia 2013 without the county anthem, is it necessary for us to have it now?
National anthem ilitengenezwa wakati ambapo tulikuwa na uhuru na tulikuwa na furaha, lakini katika county yetu ya Vihiga hatuna maendeleo. We have nothing to celebrate, so they should focus na maendeleo kwanza ya wananchi, ndiposa tuende kuandika sasa anthem, tusherekee yale maendeleo ambayo tutakuwa devolution itakuwa imetuleta.
Wakati tulikuwa na extravaganza in Kaimosi, alipromise kwamba huu mwaka wa 2025 atahakikisha kwamba kuna budget ya vijana, na kisha atahakikisha kwamba kuna studio na all that. Hizo vitu zote ambazo alipromise hawajaweka kwa budget.
Mtazamaji, mwana blogu Ndiang'ui Kinyagia amefika mahakamani asubuhi hii baada ya kutoweka mnamo Juni 21 kutoka eneo la Kinoo, kaunti ya Kiambu. Mapema leo, wakili wa Thuku alitoa taarifa akidai kuwa Ndiang'ui amekuwa akijificha na kuwa hakuwa ametekwa nyara. Haya yanajiri huku mkuu wa DCI akitarajiwa kufika mahakamani.
Hearing for the petitioner alongside Mwaura Kabata, Vice President of the Society. Today is the first petitioner. Hosea Manuel, Council member. Hosea has stepped out, but he is within. Tom Kopere, Council member.
Present, my lord.
Willis Otieno.
I'm present, my lord.
Evans Ogada.
Present, your lordship.
Moses Mutungi.
Present, my lord.
Is the counsel on record from VR Advocates.
Mutungi, like a bucket.
Wangare Ragai.
Kagai.
Wangare Kagai. My eyes are deceiving me. Director.
PIL.
LSK.
Present, my lord.
Abna Mango.
Present, your lordship.
Babu Owino, the Honorable Babu Owino, I should give him his full title.
Present, my lord.
Nuldin Kagai.
Present, my lord.
Pius Oyo.
Present, my lord.
Joki Sara.
Present, my lord.
Mudoni Boro.
Present, my lord.
Vincent Kisukwa.
Present, my lord.
Brian Mushiri.
Present, my lord.
Ochieng William.
I'm present, your lordship.
And for the respondents, I can see he has a team now. So I will ask you to introduce yourselves.
Good morning, Your Lordship. My name is Emmanuel Victor. I am here together with Mr. Christopher Marwa and Millicent Kiragu for all the respondents. Millicent Kiragu, Christopher Marwa, and myself.
May it please, my lord. Yes. My name is Kibe Mungai.
Maybe before Mr. Kibe Mungai says anything, I should say that we were actually ready and eager to proceed, and especially on the issue of compliance, but I give way to my colleague, Mr. Kibe Mungai.
My lord, just for the record, Kibe Mungai appearing with Mr. Kirago Waduta, who is on the way, he is down there, and Mr. Wahome Duku.
I'm present, my lord.
For the family.
Your Lordship, before my senior Mr. Bita proceeds, there is the preliminary issue of compliance that is yet to be achieved, which was being raised by the senior counsel.
Well, that is why we are
very well. Very well.
It was for the respondents to deal with the issue of compliance. My Lord, we have the Director of Criminal Investigations who has come pursuant to the summons by the Honorable Court. My Lord is ready and willing to explain what we have consistently told this court. Lord, before he addresses you, my Lord, we have filed 2 replying affidavits that Mr. Maro will indicate to the court and allow directors. Pardon, my Lord? My Lord, we filed first one to the Mutunga rules that gives us 14 days. We are responding to the petition. We filed them without hearing, but well within the provisions of the law. We filed 2 replying affidavits.
2 additional.
Yes, Father.
Your Lordship, if I may. My name is Marwa. I'm on record for, we are on record for all the respondents. When we appeared before you, he had given me.
Yes, my Lord.
So that we complete, you know.
Yes, my Lord. I'll pick it up from where I left. My Lord, I was saying we filed 2 further affidavits. Sworn on. They were sworn on the 2nd day of July.
Yes.
The first one by Sergeant Patrick Bwire. Patrick Bwire. Yes. And my Lord, the 3rd affidavit, that is a further affidavit, was by Corporal Leonard Cielo, sworn on the 2nd day of July, 2025. They respond both to the motion and to the petition, and they are filed within the provisions of the Mutunga rules that gives us 14 days to respond. Yes. My Lord, we have in court present the Director of Criminal Investigation, he is ready to explain to the court pursuant to the orders that we issued. Yes. So, don't no,
does he still want to proceed?
He has already introduced the affidavits that he wanted to introduce.
Yes. My Lord, I think before further proceedings may take place, I wish to indicate that this morning, I believe 30 or so minutes ago, we uploaded an affidavit sworn by Lilian Wajiko Getonga, a cousin to Mr. Ndiang'ui Kinyagia. Lilian Wanjiko Getonga, let me indicate first of all, she's an advocate of the High Court of Kenya, and she's also a cousin to Ndiang'ui Kinyagia, the subject matter of the Habeas corpus. We have availed a physical copy in addition to the one that we have uploaded. And basically, this affidavit, it has been served. This affidavit is indicating that yesterday at night, in the evening, late evening, the deponent, Lilian, was informed by Ndiang'ui Kinyagia that he was well and safe and was calling from an undisclosed location. I had heard.
So the second petitioner informed the deponent that
he was safe and but in an undisclosed location. Yes. The second petitioner and Mr. Wahome Dhuku called me at about 9 p.m. yesterday.
The second petitioner?
No, the mother.
The mother to the
and yes, and Dhuku. And I had a meeting earlier with the mother at around 5 p.m. in my office.
So the mother to the second petitioner?
Yes, and Wahome Dhuku called me and notified. Wahome Dhuku is my co-advocate.
Yes, calling me your learned friend.
My learned friend, Mr. Wahome. Sorry, my lord. Sorry, my lord. And my learned colleague, Mr. Wahome Dhuku.
He sounds like he's a stranger.
Sorry, my lord. Yes. And
so they called you?
They called me, yes, 9 p.m. yesterday. Last evening. And I informed them that if given the... Oh, they informed me, my lord, to inform me about the telephone conversation between Lilian Wajiko and Ndiang'ui Kinyagia. My lord, since the mother had instructed me to come and appear for the family, I informed my learned colleague, Mr. Wahome Dhuku, that it will be important the person who had communicated with Ndiang'ui Kinyagia to swear an affidavit, which I will file on behalf of the family.
So that's why you had to file the affidavit?
That's why we had to file the affidavit. Because I had not talked with Ndiang'ui myself.
Yes.
The father.
Let's remain there.
Yes. Yes, my lord. So I also informed them that because this was a matter that was going to appear before you this morning, that they ought to get in touch then, Mr. Ndiang'ui Kinyagia, and inform him that it would be prudent, that was on my advice, that he should be able to come and appear before you this morning.
You asked them?
Yes, I asked them to ensure that he's present for these proceedings today.
So,
At about 10:40, today, Mr. Lane colleague, Mr. Zuku and Lillian walked into this court, accompanied by Ndiang'ui Kinyagia. I have had a brief conversation with Mr. Kinyagia.
You've seen him.
I've seen him.
You had a conversation.
he's right.
A short conversation with him. He appears very traumatized and sounds as such.
Yes.
Very traumatized. He both looks it and sounds it. And therefore, because you are in court and the cameras were all over photographing us, I have not had a session to debrief him on the relevant matters that are the subject of these proceedings. Therefore, apart from him confirming his very deep fear for his life,
So he expressed.
he expressed, yes.
Yes.
I would like, and I request this honorable court to grant the family and myself, they have all met in court when I was meeting him, to grant time for us to be able to talk to him in confidence and in privacy. And since he still appears to be very traumatized, we urge that any time in the course of next week, we'll be given an opportunity to come back to this court, accompanied by him, so that he is able, and ourselves we are able, to be of further assistance to the court. I regret the fact that I cannot be of further assistance at this stage until we have had a proper session with Ndiang'ui Kinyagia to know exactly what was happening during those traumatizing 10 or so days when he was away. So that's all, my lord.
So you show the court the morning.
My lord, Mr. Ndiang'ui, please stand up. That is Mr. Ndiang'ui.
Make your way here.
Make your way here.
My lord, as he makes his way there, just for clarification on what my learned senior was talking about, the affidavit indicates that the deponent was contacted on Tuesday Not yesterday. So for the correction of the record. No.
Yes, I've seen what you're saying. Allow you to record you.
Yes, Your Honor. In any case, it's clear on the face of the affidavit itself.
Yeah, that's what I'm saying. I've seen it. So what are you saying?
I was just pointing out that correction.
Second petition. Contacted William.
On Tuesday evening.
Tuesday was first.
Tuesday was first, yes.
Yes, on 1st of July.
It's correct, yeah.
You appear to have beards. I can take the seat. So who else wanted to say something? Petitioner's counsel?
My Lord, we are happy and relieved that the second petitioner is in court and appears well. But there are procedural issues of compliance, which I believe we can proceed with still, now that the DCI is here. There are issues about the modus operandi, because these cases are becoming so many, and directions of this court, after listening to the answers the DCI may give, may help save the court the time we have spent. So we are seeking your indulgence that now that the DCI is here, we at least can deal with matters of compliance today. And any other procedural issue we might wish clarification from the DCI. And I want to say, when an application like this comes to court, it is not just about the person for whom the matter is brought. It's also about for the rule of law and for the safety and well-being of everyone. So we'll be happy to proceed with the DCI.
What? Yes, I know where you're getting.
Look at the subsequent like I issued last time. Why
the final.
Why I knew that.
Okay, yes, I'm seeing now number 5. But this is not the right one. Can I have the one of that here?
Yes, madam.
Can I go beyond
where is the
what I wanted this month?
I believe whatever hearing is there today is subject to the directions that were made, but I cannot say.
Because you've made a specific.
Yes, I have.
and you want to participate.
Yes, we would like to participate. Yes, but the petitioners can speak for themselves.
I agree.
Yes.
I have the petitioner, second petitioner in court.
Yes, the second petitioner is in court, and I'm
wanted
confirming
him
that.
for alive.
Yes, that is true.
I have him alive.
Yes.
That's what you want me to do. Once I have him alive, you have requested and you need time with him.
Yes, I do.
And it's important.
Yes.
So, senior counsel, I feel I'm not deciding, but I think the fairest thing to do is to allow the family and you lawyers have a conversation with the second petitioner, and then after you have that conversation, then we will decide how to proceed next. My intention this morning was to have him, and I have him. So I present him to the Kenyans that he's here, he's alive. So any other thing is now after you people take fresh instructions. Am I right? Who thinks we are not?
We are most obliged. It's just that we thought we could take advantage of the presence of the DCI, because apart from that, there were compliance issues.
Yes, just let them finish, Mr. Bitt. I will come to your side.
Issues which we raised on the...
We are not doing the petition. I still have the petition to dispose of.
Okay, then with that I will say...
We are at the preliminary stage. We were looking for him. We have him.
And we are relieved.
So can we still have a petition to deal with, Mr.
Yes, my lord.
Kabata?
In fact, my lord, we still have a petition to deal with.
Yes.
And in the interim on that application, we are relieved that the second petitioner applicant has been found. From our position today, we had come to dine, and our food is here. And so, it is metaphorical. It is metaphorical. Okay, I withdraw. I am saying, my lord, we had come to dance. It's our work as lawyers and our witnesses in court. We may miss this opportunity. It is a golden opportunity. I am reading this in line with what was found in by your brother Justice Mugambi in petition E436 of 2024 and your brother Mwamuye in E0714 of 2024, that orders of the court are not pious orders. They have to be complied with. Now that the Director of Criminal Investigations is here, there may be questions that we may need to ask to prepare ourselves in the debrief that we will come to explain to court. He may elect, as we have seen before, my lord, on the day when, and his brother, Mr. Masengeli is here, on the day when the court wants to exercise its prerogative power, the petitioners are usually found. It is a modus operandi. Every time when they are almost getting to the corner in court, the petitioners are found. Now, since the director is here, my lord, we intend.
I will give direction.
Yes, my lord.
You are making requests.
Yes, ma'am.
I will give direction.
Okay.
I want first to take into account the request by the family. It's paramount to me.
Absolutely.
They want to talk to the second petitioner. We still can ask him to come. But if you want to ask him questions, I'm here, he's here.
And your directions, my lord, are very well noted. And
No. If you want, he's here. So let's have it in order. That we have the DCI, we have the petitioner. Right? The person I wanted. If you want to ask him questions, he's here. I'm not saying we will not. But I want us to agree how we proceed. Does the family have first opportunity to talk to him? There may be something.
I'm actually drawing from your wisdom, my lord, that in this particular instance, as we left last time, the primary concern was the life and liberty of the petition, second petition. And we are glad that he's here. He's alive, he's breathing. At this point also, Mr. Min has acted to comply with your orders. He's here. And on the petitioner side, we were ready to cross-examine him. But the family has made a request, which is also reasonable. You have a traumatized citizen who, for all intents and purposes, may be in a daze not even fully understanding what we are saying or going through. For the request to debrief, give him time to compose himself, to understand the circumstances under which he couldn't be traced. Then we reconvene. Once the second petitioner has debriefed with counsel, probably gotten medical attention, and is ready now to participate in the petition, all parties come back here. And my lord, the only point you are stressing, which now I'm guided again by your counsel, is the presence of Mr. Amin. We may need him. My vice president, I as deputy designate, my vice, would have wished it happens today. But in the circumstances, it may not be possible. No, I'm talking of, and I was going to say, my lord, I was actually coming to that. And also recognizing that he's in charge of criminal investigations in the entire country. And getting him is sometimes difficult. And now that he's here, at least to the extent of the first petitioner's counsels, we can take our bite at the cherry when it is still fresh and here. And we question him, we preserve, so that we don't fall of instances where when we seek him to come to court, he says he has gone for an operation in Baragoi. Which may be a genuine operation or not genuine, as sometimes happen. So having blocked his diary for today, no prejudice will be suffered if we proceed with him today. But if the court is minded to consider the family request, we will equally be guided. And also, my lord, of import in this particular instance that we don't lose focus on, in the replying affidavit signed by the respondents in paragraph 20, the question, the affidavit sworn on 30th of June 2025 by Samuel Itegi. Paragraph 20. There's a live issue which I will not wish that we gloss over. If the second petitioner were to leave court today, there is a real danger that he may be arrested or detained by the respondents. On his behalf and in the interest of justice, I'll pray that when the court is making directions as regards to the second petitioner, the court consider issuing an order restraining his arrest, because any arrest ends up in court, and he can be bonded to attend to this court when required, so that the question that should be of our primary concern at this point is him getting medical attention and socio-psycho support.
In fact, my lord will be happy if the director will just tell us that they will not arrest him for today, so that we go probably also for the court to feel the presence of the.
I confirm the application for protection of the second petition at this time is also one we are going to make, so I urge the court to make it in giving its directions.
Yes, Mr. Bill.
Yes, my lord, thank you. My lord, I have an application to make. The first application I wish to make, my lord, is that if the court will be gracious to summon the deponent swore an affidavit in support of the petition, one Florence Muturi, to attend court during the next hearing for us to cross-examine.
That's okay.
Because, my lord, there are certain facts that she want to that have led us to this. There are two affidavits. The first one was sworn on the 1st day of July 2025. 2025. 1st July 2025.
Yes.
And there is another one sworn on the 24th day of June this year. 24th. The first one is sworn on the 24th day of June 2025. Yes, that is the first affidavit. The second one, my lord, was deponed to on the 1st day of July 2025, my lord, both in support of the petition and the motion. Secondly, my lord, in terms of the directions of the court, my lord, now that the DCI has come in answer to those summons, we pray that those directions be discharged as regards the appearance of the DCI. And thirdly, my lord, the DCI, in light of what has been stated, would wish to be given an opportunity to speak on behalf of the Directorate, because to address you, my lord, on behalf of the Directorate, because they feel that they have not been treated fairly as regards this case, and they need to be heard. An opportunity to be heard as regards all the issues raised. My lord, fourthly.
So, I didn't get you.
Yes, my lord, he wishes to be heard. He wants to be heard.
Today?
Today, my lord, before you. Now that you've summoned him, he wants to be heard because they have not been treated fairly in this matter.
They say so.
Yes, they allege they need an opportunity really to state the facts as they are. My lord, an application has been made orally. I am not privy to the basis of that application, my lord. The one for... There were several applications made by Mr. Kibe and Mr. Wakabata. Yes, and Mr. Willis Otieno. I pray that they make a formal application so that we have an opportunity to respond, my lord.
You are mixing up.
My lord, I've addressed you first.
See whether we are speaking.
Correct.
Mr. Kibe made a specific request
Yes.
on behalf of the family that they would want time with the second petition. That's number one, and that's the primary application I had from Mr. Kibe. So, what do you say to that?
My answer is...
His
yes.
and the other people.
My answer is simple. Mr. Kibe is not a party in these proceedings. He is not a party in these proceedings. I have no problem with him meeting the second petitioner in whatever capacity out there. But he is not representing any party in these proceedings. If he was, I would be in a position to respond to an application made by a party to the proceedings. Yes, my lord.
So So you're not able to respond.
My response is Mr. Kibe is not a party in these proceedings. He cannot make an application in proceedings that he is not a party. He has not been joined. He is not a party in these proceedings. There is the application made by Mr. Willis Otieno, my lord. And I believe, my lord, if you look at the notice of motion, filed by the petitioners in this case, there is a prayer that was sought for their unconditional release and prayers of Habeas corpus, my lord. If you look at prayer 8, my lord. It is in the notice of motion, my lord, the one that you gave directions on, dated 24th of June. You've seen it, my lord? Yes.
Which one are you referring to?
I'm referring to prayer number 8, my lord. Prayer number 8. So that, my lord, this is the prayer that has been sought. We have responded to this motion, my lord. And we are ready for it to be urged, my lord, inter partes. And I believe it is only fair that we deal with this motion, my lord, before we consider any other oral application, my lord. I believe that you're coming for directions, my lord, so you can give directions on the hearing so that we conclude with these interlocutory applications, my lord. I think that is my brief response.
My lord, in response.
Before you respond.
Yes, my lord.
One would be to find out whether I got Mr. Peter. What you say, Mr. Peter, is
yes,
that you want the DCI to be allowed to speak.
Because you called him.
Because, yes. I'm not saying I didn't call him. Why are you here?
Yes.
That's all I want to hear, because the petitioner, the family has a specific request. The petitioners, counsel for the petitioners have their way of looking at things. So I want to know whether you agree that we hear him today, despite the request from the petitioner's family.
Despite the request from those on his schedule.
I have no problem. I just wanted to know whether that's the way you would want us to proceed, so that I give directions.
Yes,
Mr. Mungai?
Yes. My lord, first of all, it is very strange for the Honorable Attorney General, Representative Attorney General, the Constitution in Article 156 of the Constitution, I believe sub-article 6 talks about the Attorney General shall promote, protect, and uphold the rule of law and defend the public interest. This is a habeas corpus application. It's the subject matter of the petition. In a habeas corpus application, and by the nature of habeas corpus, the family is a necessary party, and invariably habeas corpus application are instigated or instituted at the behest of the family. And therefore, for purposes of these proceedings, where the second petitioner is indicated as Ndiang'ui Kinyagia, who was not there to give the instructions, that should be construed as the family of Ndiang'ui Kinyagia. So the family of Ndiang'ui Kinyagia is already a party. And if it was not expressly, it is a necessary party whose right to participate is inherent in the nature of habeas corpus. But if, for whatever reason, it is necessary to comply with technicalities, notwithstanding Article 159 of the Constitutions, that litigation, particularly under this jurisdiction, shall not bear regard to undue technicalities, I wish, pursuant to Rule 10, Sub-Rule 4 of the Mutunga Rules, to make an oral application for the family of the second petitioner to be added to the proceedings as a third petitioner. But the primary position is that they are already parties if the second petitioner is a party. My Lord, and that is pursuant to Rule 5. Is it Rule 5? Rule 5 of the Mutunga Rules, that this court has jurisdiction under those two rules, 5 and 10, to make such an order. And my Lord, the last one is a is a question of common sense and propriety of proceedings. The notion, as urged by the Attorney General, that you can have proper habeas corpus proceedings in which your lordships can lock out the families and their representatives from speaking, would be completely unusual. The only issue that we need to clarify is that when I advised that Lilian Wanjiko Getonga to file an affidavit, I advised that she would come as an interested party. So for purposes of Lilian Wanjiko Getonga, who gave us the information, will appear as an interested party. But now that he is there, and when we speak to Ndiang'ui, the second petitioner, then we would be able, for purposes of completion of the habeas corpus proceedings, to be of further use as are dedicated to the court. Because all of us, even out of curiosity, would want to know where was Where was he? And why has he also just appeared the day before? We would want to know that also, if nothing else, for purposes of curiosity. Therefore, we need to talk to him as we had requested, but we can formalize the proceedings because we need to apply for his protection. We are most obliged, my lord.
My lord, you have a right of reply on my application. The question of the liberty of the individual and the need for him to be given an opportunity to get medical attention. He looks physically traumatized. I'm not an expert, but applying my elementary knowledge of human health. That's exactly what I was going to say, that we should not talk too much, but we should preserve by issuing the orders that allows his liberty and an opportunity to access medical help.
Where I am, we are losing the point. I have the DCI in court. I have the petitioner in court. The family has requested to have a conversation with the second petitioner. I have parties who want to keep us here. We want to hear the DCI. Mr. Bita says they were not treated well. He will tell us. The other side wants to cross-examine the DCI. So how do we proceed? Which one should we give preference to? It is something, a decision you have to make conscientiously. If the health of the second petitioner is primary, or do we keep the DCI here?
And what I think we should give way to the family and parties. Those who are needed by the court can come on the next date. The application was about the well-being of the second petitioner. And I think, in all fairness, we ought to give way. Even though we were rallying to go, we should hold our brakes.
Mr. Bita,
Yes, my lord.
how many deponents do I have? I have 3 affidavits from Buire. Is it mistaken? There's one called second respondent's father affidavit. That Buire seems to be the same.
No, my lord, the first affidavit is by someone to change.
That I have.
Yes.
That's the original.
That's the
Yes, that one we have.
Then we have a second, a further replying affidavit by Leonard Cielo. That one is sworn on the 2nd day of July.
So is that one of Buire?
Yes.
Mm-hmm.
So there's Leonard Cielo, and then there's Patrick Buire.
The first one is?
The first one is by Samuel Kuti.
Yes.
That is the first one.
Yes. Yes.
The second affidavit is by Leonard Cielo.
You don't have that one?
You don't have it.
The third?
The third one is by Patrick Buire.
I have 3 copies by Patrick Buire.
Maybe they printed the same thing. But we'll supply, we have copies of it.
So how many do you, can I check? Can I see it online? All these are from Buire. Okay, but it's here. Can I check? Let me check. Did you upload the one of Cielo?
Mr. Marwa actually uploaded it. He was here, he can speak for himself. personally.
No, you are now the lead.
Yes, my lord.
I'm told you are his senior.
Yes, and I trust him.
So how do you throw it back to him? Because you are the one. I'm looking at the system.
Yes.
It is the same affidavit by Buire that was uploaded. It was uploaded twice. Someone else who can assist me, maybe we are wrong on this end. Let's check. No, it has to be here, because this is the file. Your people can upload it now. But let's see the have you seen the one by Sele?
Yes, my lord.
You have one by Sele? We don't have it here.
My lord, he can re-upload it.
What's the problem? It's no. We are still trying to confirm. You know, the systems are sometimes slow. Yeah, it's here that you uploaded Buire twice. So I'm sure it is because of the urgency. So anything else?
I wanted to address your question on an issue that Mr. Peter has raised, but my senior Mr. Perry, I see, is in court and has better particulars of that. He's 38 years in the profession, my lord, and to me that counts for something.
Please, my lord. Leaving what my vice president has said, I am the second senior most after senior counsel Karua. But I just wanted to just bring into context on the 4 applications made by Mr. Bita. The first one was on the summoning of the CEO of the Law Society. I appear for, together with the rest, for the Law Society and the second petition. As to that application, the Law Society has no objection. In respect of the first application by Mr. Bita on the question of cross-examination, which can be dealt with at the appropriate time. What I am worried about are the second and third applications by Mr. Bita because they go against each other. The second application was to discharge the personal appearance of the DCI, but the third one is to give him an opportunity to address court, which is sort of supporting what my other learned colleagues had said about having a bite at the cherry today. So that third application also supports what the other parties were saying, that he can be able to say something. He cannot just say it and go. He may have to be asked some questions in relation to that before he is discharged. So while dealing with those 2 applications, you may have to consider how to balance the 2 of them in relation to having given him the opportunity and then thereafter discharging him, and whether he'll be cross-examined. Then as to the question of a formal application being filed by Mr. Kibe, I think that has been addressed, and that was the 4th limb of Mr. Bita's application. So those are the 4 issues I wanted to bring to context for purposes of then when your lordship is giving directions, then you can be able now to balance what Mr. Bita requires, what we also require, and the fact that at a later stage, since the other affidavits are supporting the petition, they can be dealt with in the main petition, and the deponents, including whoever may be required, a notice can be given as is required by law that we will want to cross-examine you on these allegations or these depositions in your affidavit dated this particular day. That will be all.
Let me make it clear that the court is never addressed. It's the lawyers who address the court on specific items. So if the DCI wants to speak to the witness box, he's here as a witness of the court. He's led what he wants to say, and then he will be subject to cross-examination.
Thank you.
Those are the directions. If we are going that way, we clear the way for that. Bearing in mind, I have a specific request from the family. So if you want us to go that way, we'll take the stand, be led for the reasons that the court directed he be here, nothing more.
I think my learned senior, my learned class can be able to.
So you look at the directions are issued. He was to be here for a specific mission. We are not digressing any other issue. If we are sticking to that, that's what we are doing, Mr. Bita.
Yes, let me address you on that, because obviously there are some instructions. He says he wants to respect the wishes of the family. Now that he has answered the summons of the court to appear, and the second petitioner is present, that you discharge him, because those summons have been obeyed.
So abandon the other. Yes. You withdraw the other.
No, you have. No, he's telling me to abandon the other applications, my lord.
It's already on record. An oral application is already on record.
He's telling me to abandon all applications. So as regards the DCI, my lord, is that you discharge him. He doesn't wish to oppose the wishes of the family. Those summons are actually spent, my lord.
Mr. Bita, you have filed all you wanted to file in response to the petition.
To the petition, no. I was just dealing with this aspect because you know there are other parties. The accusations against other parties.
So you have not filed responses to the petition?
As regards the other parties, but as regards the IG, the DCI, both in their public and private capacities,
you have filed. And those are the primary parties?
Those are the primary parties.
So that's where my concern is. Is there any other thing you want to file in form of a response?
I will file grounds of opposition on behalf of the other parties that are not primary. The Attorney General and the Cabinet Secretary for the Interior. Although today is Thursday, by Monday I will file this.
You will have filed. I'm suggesting that we go directly to the petition.
That is okay.
You agree? The petitioners?
We are fine with that.
Well, I can also file appeal.
That's a response, Mr. Bita, in my court. Ask Mr. Maro, I think he comes to my court so often. POs are our responses to the petition.
I'm not been to your court longer than Mr. Maro.
Oh. I don't know when last you were in my court. But I'm sure you know.
Yes, ma'am.
So, next week, so I can give you 7 days?
Yes, ma'am.
Senior counsel, I restrict submissions to 10 pages. How many pages would you want to have?
I think 10.
10 will do.
Would do, yes.
We are dealing with the petition because there are specific issues you are raising.
Then make it maybe
15?
15, yeah.
Mr. Bita, would 15 be fine with you? Okay.
My Lord, before you give your directions, perhaps you consider that the case be disposed by both submissions and viva-voce evidence, because we still have that cross-examination.
Yeah, so does it make sense to file submissions before?
It doesn't.
Doesn't?
We actually should have the cross-examination before submission. Submissions are a wrap-up.
Yes, sir.
Yeah.
That's why I'm looking at, we have to change that. want us to agree on a date we can have the hearing. This matter will be heard through viva voce evidence. We don't have dates. But we will try to see, because of the nature of this matter. Robert? Robert? Senior counsel, how long will you take to do your witness?
I think
We already have the affidavits. We will have the affidavits.
yeah, but we are not even talking of our witness. We are talking of cross-examining DCI and the deponent.
I'm talking of your case. How much time will you take to present your case?
I think our 1 day then.
1 day.
Yeah, not more than 1 day. Yeah. It could even be less, but to be on the safe
You know, I have affidavits already. Yeah, they will come here and adopt affidavit and be cross-examined. That's the way we proceed.
have requested for somebody without any affidavit. The DCI. Because it is his officers who swore, yet.
We will reach there. Let's deal with you. Yeah. I'm looking for your side. Don't worry, because they will come and they will cross-examine. Do you have it?
3 hours for highlights, but examination will be a day plus. We had prepared that.
So which day? Are you suggesting there are days you come without preparing?
No, but because of the menace of the problem we are talking about, we have come loaded more.
So these two. And these two. Because of the threat that will take so long, I'm suggesting 17th and 18th of July for hearing.
May I request we push another 2 days? I have a personal problem. I'll be out I'll be returning on 16th and 17th. I'm in Kampala.
Okay.
If I could request.
Robert, do you have any other
I'm
dates?
Kampala, I'm lead counsel.
No, you said you are not available, so we. No, she's in Kampala. When are you in Kampala?
On the 17th.
17th. Will you fly back? You don't know.
It's a day trip.
No, will you fly back the same day?
Yeah, it's a day trip. That's what I'm saying. Going in the morning, back in the evening.
So we can take 18.
Yeah.
Can take 18. And then 24.
No, they will come.
So we will have to stagger it. We take 18th, and then we proceed on 24th. How is that? Mr. Bitter?
18th, that's okay.
24th. That's okay.
Some time allocation or not?
I will come to that. Let's just agree. So I suggest we start 10:30 each day.
That's okay,
Hmm? That's okay?
That's okay.
So the court issued specific orders and directions on the DCI to come to this court today and explain the whereabouts of the second petitioner or produce him. Today, the second petitioner has been presented to court by the family, and the family has made a specific request to have time to speak to him and get to know what has transpired, and they also give instructions to the advocates. Mr. Bitter, for the respondents and the DCI in particular, does not oppose this view, and since today was for explaining the whereabouts of the second petitioner, and now that the second petitioner is in the court, it's proper and appropriate that the family has time with him together and the advocates and take instructions and possibly have him treated. For that reason, we issue the following directions. This petition will be heard by way of oral evidence. Respondents have 7 days to file responses to the petition if they have not already done so. Once they serve, the petitioners will have 7 days to file a supplementary affidavit if need be. The families granted time to have the petitioner with them and take him to hospital for medical attention. This matter will be heard on the 17th and 24th of July. 18th, sorry, I had already 18th of July and 24th at 10:30 a.m. both days inclusive. In the meantime, the police shall not arrest the second petitioner, Ndiang'ui Kianyaga, since he is now a petitioner in his court. The second petitioner may be presented to the DCI officers to record a statement if need be, and it should be presented by his advocates, but he should not be arrested or detained until further orders of this court. Thank you. So we meet on that day. Please comply with the directions. So this one was it? Sorry? Yes, you can take it. Thank you.